Ayes have it. Minister of Finance will be allowed to make his contribution until its completion.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 139, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Act, Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Actions Task Force, be now read a second time. Mr. Speaker, in accordance with Standing Order 51, I seek the leave of the House to debate together with this bill the Counter-Proliferation Financing Bill 2025, which relate to the same subject matter.
Leave has been granted. Minister of Finance.
Thank you again, Mr. Speaker. And let me also thank members of this Honourable House for agreeing to consider them together, because these bills are not just abstract. They are about giving our country the tools to fight back against crime and corruption. They are about protecting the ordinary citizens, Mr. Speaker. Mr. Speaker, just for the record, allow me to read again the titles of the bills that we are proposing to debate today. The first bill, An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Act, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2009, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force. The second bill will be an act to provide the implementation of the recommendations of the Financial Action Task Force, the FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act and for related matters. Mr. Speaker, these two vital bills provide strong protection against both crime and criminality. With their passage, Trinidad and Tobago will have a robust legislative framework to properly deal with the proceeds of crime, including cross-border activities and the kind of white-collar crime that has already robbed this nation of billions of dollars and destroyed thousands of lives. Mr. Speaker, we promised the people that we would tackle these issues head-on. Today, with these bills, that promise made is now a promise kept. Mr. Speaker, I start first with the Miscellaneous Provisions FATF Compliance Bill 2025, and then I will move on to the Counter-Proliferation Financing Bill 2025. Allow me to provide an introduction to the Miscellaneous Provisions FATF Compliance Bill 2025 for members present and the listening audience. At first glance, Mr. Speaker, this bill may appear to be a highly technical piece of legislation, but in truth, it is one of the most consequential bills that will come before this Honourable House during this parliamentary session. Its importance lies not only in the amendments it introduces across 13 different pieces of legislation, but in what those amendments mean for the protection of our financial system, our international reputation, and ultimately our economy and the welfare of our people. Mr. Speaker, the passage of this bill is a crucial and substantial initiative by the government of Trinidad and Tobago to fortify our legal and regulatory framework against money laundering, terrorist financing, and proliferation financing. This bill comes at a critical moment, Mr. Speaker. Trinidad and Tobago is preparing for the on-site fifth-round mutual evaluation for anti-money laundering, countering the financing of counter-terrorism. My apologies, Mr. Speaker. This bill comes at a critical moment. Trinidad and Tobago is preparing for the on-site fifth-round mutual evaluation for anti-money laundering, countering the financing of terrorism, counter-proliferation financing by the Financial Action Task Force in March 2026. Mr. Speaker, this evaluation is not a routine administrative exercise. It is a searching, rigorous, and demanding assessment of how effectively our nation complies with the global standards on anti-money laundering, counter-terrorist financing, and counter-proliferation financing. The FATF's 40 recommendations and 11 immediate outcomes set the benchmark, Mr. Speaker. They require that countries not only enact legislation, but also demonstrate real, measurable effectiveness in preventing, detecting, and prosecuting financial crimes. In this environment, Mr. Speaker, where effectiveness carries as much weight as technical compliance, this bill is a lifeline. It ensures that Trinidad and Tobago will enter that evaluation with a strengthened framework that reflects global best practice and demonstrates our seriousness of purpose. We are on this side, Mr. Speaker, we on this side are committed. And I say to my colleagues opposite that we look forward to your support for the smooth passage of this bill and the other bill to come. Mr. Speaker, we know from hard experience the costs of failing to meet FATF standards. Trinidad and Tobago in the past faced the scrutiny of grey listing. We know what it means to be viewed as a jurisdiction with strategic deficiencies. That is what happened previously, Mr. Speaker. Such a label is not merely symbolic. It reflects our ability to maintain corresponding banking relationships, raises the cost of international transaction, it discourages foreign direct investment, and, Mr. Speaker, it undermines confidence in our financial system. Every exporter, every importer, every citizen who seeks to send or receive international payments is put at risk when our financial system is not trusted. Mr. Speaker, we cannot go back down that road again. As Minister of Finance, as a representative of this government, Mr. Speaker, I want to give the assurance to the citizens of Trinidad and Tobago that this government, under the leadership of the Honourable Kamala Prasad-Bissessar, is taking every possible action to achieve full legal compliance and to ensure that our financial systems are never again compromised by the failures that existed before April 2025. Following its fourth round mutual, Mr. Speaker, Trinidad and Tobago is found to have strategic deficiencies in its anti-money laundering and counter-terrorist financing regime. As a result, the Financial Intelligence Unit of Trinidad and Tobago was placed into procedural trigger 3 of the FATF's support and compliance process and intermediate level requiring enhanced monitoring and technical assistance, particularly addressing the gaps, Mr. Speaker, related to FATF Recommendation 40 and the Egmonts Group's information exchange principles. Mr. Speaker, in its 2015 mutual evaluation, Trinidad and Tobago was found to have critical shortcomings in several other FATF recommendations. The country was partially non-compliant or partially compliant regarding foundational areas such as risk assessments, sanctions, customer care due diligence, wire transfers, and NGO sector oversight. A more recent assessment, Mr. Speaker, advised that Trinidad and Tobago has achieved full compliance in some of these areas, including sanctions, implementation recommendation 6, customer due diligence recommendation 10, and wire transfers recommendation 16. Improvements were also made in sanctions against proliferation financing recommendation 7 and information exchange or international cooperation recommendation 40, bringing us to a largely compliant standard. Notably, however, Mr. Speaker, oversight of non-profit organization, which is recommendation 8, moved forward from non-compliance to partial compliance, showing some momentum, but indicating that substantial work still is required to be done. Mr. Speaker, FATF's report titled Improving Global AML CFT Compliance, Ongoing Process, notes that Trinidad and Tobago has made a high-level political commitment to work with the FATF and Caribbean Financial Action Task Force, CFAT, to strengthen the effectiveness of its AML CFT regime and address any related technical deficiencies as a country identified as having strategic deficiencies. This was evidenced by our ongoing effort and ability to gain approval for the counter-terrorism strategy by the National Security Council, the issuance of a case prioritization policy, and the advancing legislation in a number of areas. To this end, Mr. Speaker, the FATF recommends that jurisdictions identified as having strategic deficiencies complete the implementation of action plans expeditiously and within stipulated timeframes. In advancing, the FATF proposes that Trinidad and Tobago should continue to work on implementing its action plan to address its deficiencies by 1. Adopting and implementing irrelevant measures to enhance international cooperation. 2. Addressing issues related to transparency and beneficial ownership. 3. Completing the legislative efforts to enhance the processing of money laundering charges before courts. 4. Taking measures to enhance tracing and confiscation of criminal proceeds. 5. Prioritizing and prosecuting terrorist financing cases where they arise. 6. Enacting the necessary amendments related to targeted financial sanctions and implementing measures to monitor NPOs on the basis of risk. And 7. Developing and adopting and implementing the necessary framework to counter-proliferation financing. Mr. Speaker, it is crucial that Trinidad and Tobago possess the necessary rules, regulations, and operational infrastructure that are the building blocks for an effective system to tackle illicit financial inflows and outflows, Mr. Speaker. And this government is committed to making sure that that happens, Mr. Speaker. This bill demonstrates that this government is unwavering in its commitment to strengthen our anti-money laundering and counter-financing of terrorism regime and addressing the technical compliance gaps identified by the FATF. Mr. Speaker, I now intend to examine the miscellaneous provisions FATF Compliance Bill 2025, which contains 15 clauses on a clause-by-clause basis. I also want to mention, Mr. Speaker, that there's a short list of amendments which will be circulated to members shortly. This list contains minor amendments to clauses 3, 11, 12, and 15. Mr. Speaker, Clause 1 contains the short title of the bill, which is cited as the Miscellaneous Provisions FATF Compliance Act 2025. Clause 2 of the bill provides for the commencement date of the bill, which is to be fixed by proclamation of the President, and which is necessary given the need to ensure that operational and crucial legislative requirements can adequately be addressed. Mr. Speaker, Clause 3 amends the Trustees' Ordinance, Chapter 4 of 1939. This amendment is aimed at ensuring that all express trusts are registered to allow for greater transparency. Any trust that is not registered will now be null and void. Trustees, therefore, must register within 14 days of creation or within 3 months for pre-existing trusts. They must disclose beneficial ownership details, including names, dates, and places of birth, and must notify the Registrar General within 30 days of any change. Mr. Speaker, the proposed amendments in Clause 3 are crucial for enhancing the transparency and beneficial ownership of express trusts. These are directly related to the Financial Action Task Force's Recommendation 25, Transparency and Beneficial Ownership of Legal Arrangements. Without this, Mr. Speaker, trusts can be and has undoubtedly been used as secret vehicles to launder money. By requiring registration now, updating of particulars, and penalties for non-compliance, Mr. Speaker, I am proud to say that we are closing one of the most serious gaps in our system. Mr. Speaker, the amendments modernize trust regulation by imposing mandatory restrictions, mandatory registration and updates, introducing timelines for compliance and ongoing reporting, ensuring beneficial ownership information is available to complement and competent authorities, and to introduce proportionate penalties with capped liabilities and ministerial flexibility to exempt categories of trusts. Beneficial ownership transparency is also strengthened through expanding reporting duties and access for competent authorities. Apart from strengthening compliance with FATF Recommendation 25, Mr. Speaker, Recommendation 10 on record keeping and Recommendation 35 on effective sanction is also triggered, and gaps related to beneficial ownership transparency and enhancing Trinidad and Tobago's AML-CFT framework are closed. Mr. Speaker, Clause 4 seeks to amend the Prevention of Corruption Act, Chapter 1111, by addressing gaps that were highlighted in both the FATF technical assessment and by international conventions. These amendments transform the Prevention of Corruption Act into a more comprehensive anti-corruption framework by criminalizing a wider range of misconduct, including deprivation of state revenue, bribery in public procurement, bribery of foreign officials, and embezzlement of public resources while safeguarding the investigatory process. Mr. Speaker, for emphasis, I would like to repeat that for some of the members opposite, because they fall directly in their gaps, Mr. Speaker. These amendments transform the Prevention of Corruption Act into a more comprehensive anti-corruption framework by criminalizing a wider range of misconduct, including deprivation of state revenue, bribery in public procurement, bribery of foreign officials, and embezzlement of public resources while safeguarding the investigatory process. Mr. Speaker, Trinidad and Tobago must never find itself again in the position where we were over the last few years, where the Office of the Procurement Regulator, the Auditor General, and others in this very Parliament sounded an alarm, where billions of taxpayers' dollars were spent illegally on projects that no one could verify. Billions siphoned their way into the private pockets of a few crooked individuals, all at the expense of the ordinary taxpayer. It is time, Mr. Speaker, that those who commit the crime must pay the price and face the time. Mr. Speaker, collectively, these amendments proposed in this bill expand the list of predicate offenses for money laundering, FATF Compliance Recommendation 3, strengthen anti-bribery measures, enhance the responsibilities of law enforcement, and investigatory authorities as required in Recommendation 30, and improve international cooperation by addressing foreign bribery in the context of Recommendation 37. Mr. Speaker, in addition to strengthening Trinidad and Tobago's technical compliance with FATF recommendation, the amendment of the Act to insert the definitions of embezzle and foreign public official are important to bring clarity and to ensure alignment with Article 16 of the United Nations Convention Against Corruption, which requires criminalization of bribery of foreign public officials. Mr. Speaker, the criminalization of bribery of a foreign public official further strengthens Trinidad and Tobago's ability to prosecute transnational corruption cases. Clause 5, Mr. Speaker, amends the Mutual Assistance in Criminal Matters Act, Chapter 1124, to enhance our framework for international cooperation in criminal matters, in line with FATF Recommendations 38, that is, the mutual legal assistance, freezing, and confiscation. Mr. Speaker, the reforms broaden the scope of international cooperation in criminal matters by explicitly including seizure and freezing orders, clarifying procedures for enforcement, and allowing cost recovery and sharing arrangements. They also relax the dual criminality requirement for non-coercive requests and strengthen the authority of the central authority to provide related assistance without requiring supplemental requests. Mr. Speaker, the amendments to the Mutual Assistance in Criminal Matters Act strengthen Trinidad and Tobago's international cooperation framework in several important, critical ways, Mr. Speaker. By expanding the definition of criminal proceedings to include seizure and freezing orders, the law ensures that broader asset preservation measures can be supported, directly aligning with FATF Recommendation 38. The explicit inclusion of communication and cooperation provisions enhances the speed and efficiency of exchanges, supplementing Recommendation 40, which is other forms of international cooperation. Mr. Speaker, widening the scope of freezing, seizure, confiscation, or forfeiture orders broadens the range of enforceable foreign orders and the relaxation of dual criminality requirements for non-coercive requests and authorization for the central authority to provide related assistance without supplemental requests. This removes the barriers to cooperation, reinforces compliance with Recommendation 37 and 38, mutual assistance, and Recommendation 40, other forms of international cooperation. Mr. Speaker, the amendments to the Act additionally introduces asset sharing and cost sharing arrangements with foreign states, which heavily incentivizes cooperation and ensures equitable burden sharing allowance, along with reliance on foreign judicial findings without local investigation and extension to external seizure and freezing orders, thus streamlining enforcement in line with Recommendation 38. Mr. Speaker, Clause 6 amends the Proceeds of Crime Act 1127 to bring it fully in line with FATF requirements. The amendments significantly broaden and modernize Trinidad and Tobago's anti-money laundering and asset recovery framework by expanding key definitions, strengthening confiscation and restraint order powers, criminalizing dealings with criminal property, providing legal cover for undercover operations, enhancing supervisory authority obligations, and updating the financial obligations regulations to address new risks like virtual assets. Mr. Speaker, through this, we are given real legal teeth to our law enforcement agencies, including the courts, in this battle against crime. Mr. Speaker, with the amendment of the definition of property to now include virtual assets, bearer instruments, and natural resources, and the replacement of drug trafficking with the wider concept of criminal conduct, The law now captures all forms of illicit proceeds, reinforcing FATF's recommendation 3 on money laundering offences and FATF recommendation 15 on new technologies. Mr. Speaker, confiscation and restraint orders are strengthened, given courts and the DPP flexibility to initiate, vary, and enforce orders even when asset values change, upholding the requirements of the FATF recommendation 4 to prioritize asset recovery. Mr. Speaker, I repeat, we are giving power and teeth to the authorities to go after money laundering and asset recovery. Mr. Speaker, law enforcement will now be empowered to use covert techniques such as undercover operations and controlled deliveries with legal protection, bolstering investigative capacity as required in FATF Recommendation 31. Supervisory authorities will be mandated to apply risk-based monitoring of financial institutions and listed businesses, while National Anti-Money Laundering Committee, its duty of conducting and upholding and updating the national risk assessments to guide coordinated responses to money laundering, terrorism financing, and proliferation financing, is enhanced to encourage a risk-based approach to identifying AML-CFT threats in line with FATF Recommendation 1. Mr. Speaker, the new schedule to the Financial Obligations Regulation introduces a structured framework for classifying breaches as moderate, serious, or very serious, and links the materiality of each contravention to corresponding administrative fines. It establishes a revenue-based methodology for listed businesses and an asset size-based methodology for financial institutions, ensuring proportionality between the size of the entity, the gravity of the breach, and the penalty imposed. Mr. Speaker, together these reforms create a comprehensive and flexible framework that enhances asset recovery, improves financial transparency, strengthens regulatory oversight, and equips law enforcement with robust investigative tools, thereby closing the substantial FATF-identified gaps and aligning the country's regime with international AML-CFT standards. We are doing all of that, Mr. Speaker, within the first 6 months of having come into office. Mr. Speaker, by clarifying liability for compliance failures and broadening the scope of predicate offences, the legislative regime enhances deterrence and improves compliance with FATF Recommendation 35 on sanctions, Recommendation 10 on customer due diligence, Recommendation 18 on internal controls and foreign subsidiaries, and Recommendation 26 on regulation and supervision of financial institutions. I turn now to Clause 7, Mr. Speaker, which amends the Anti-Terrorism Act, Chapter 1207, and closes major gaps in our counter-terrorism financing regime and gives effect to a number of international conventions, Mr. Speaker. The amendments to the Anti-Terrorism Act and its regulation greatly improves Trinidad and Tobago's counter-terrorism framework by expanding the definition of property to include virtual assets and internationally protected persons, thereby ensuring compliance with FATF Recommendation 5 on terrorist financing and Article 2 of the 1999 International Convention for the Suppression of the Financing of Terrorism. New offences, including the prohibition of unmarked plastic explosives and the acquisition of nuclear material, reinforces Trinidad and Tobago's commitment to complying with conventions such as the 1991 Convention on the Marking of Plastic Explosives and the 1980 Convention on the Physical Protection of Nuclear Material. These amendments refine Trinidad and Tobago's international treaty obligations while reinforcing FATF's Recommendation 5 and 7 on terrorist financing and targeted financial sanctions related to proliferation. Mr. Speaker, the strengthened asset freezing and targeted sanctions regime covering erroneous listings enhances the Attorney General's powers, immediate freezing and reporting duties for financial institutions and listed businesses, and a tiered system, administrative fines and framework. This brings the Act into alignment with FATF Recommendation 6 on targeted financial sanctions related to terrorism and terrorism financing. Mr. Speaker, the enactment of provisions in the Act relating to due diligence and suspicious transaction reporting implement FATF Recommendations 10 and 20, while new investigative powers speaking to control delivery, undercover operations, and ex parte applications align with FATF Recommendations 29 to 31 on operational and law enforcement requirements and Articles 19 to 20 of the UN Convention Against Transnational Organized Crime 2000, my apologies. Mr. Speaker, stronger penalties, including life imprisonment and multi-million-dollar fines, will ensure compliance with FATF Recommendation 35 on effective sanctioning measures. Collectively, these reforms close major legislative gaps, operationalize obligations under 7 major UN counter-terrorism conventions, and strengthen our national security and international credibility through full alignment with FATF standards. Mr. Speaker, Clause 8. Clause 8 amends the Police Service Act, Chapter 1501, by inserting 2 new sections on the admissibility of evidence and relevant definitions in respect of controlled deliveries and undercover operations. We are providing substantial support for the operationalization of FATF Recommendation 31, which require competent authorities to have the necessary investigative powers to combat money laundering and terrorist financing. We are putting power into the hands, Mr. Speaker, of those who need it most to fight crime. Mr. Speaker, the strengthening of investigative powers of the police service against organized crime, the provision of statutory backing for the use of controlled deliveries and undercover operations, and guaranteed admissibility of covert evidence, closing loopholes where such evidence might otherwise have been challenged as inadmissible, aligns Trinidad and Tobago with FATF Recommendation 30, that is, the use of special investigative techniques for treating with money laundering and terrorist financing cases. To this end, Mr. Speaker, law enforcement can now conduct covert operations against drug cartels, terrorist financiers, arms traffickers, and money launderers with an assurance that resulting evidence will be admissible in court. This is expected to lead to more successful prosecutions of complex and high-level criminal cases. We are taking the fight to the criminal at every level, Mr. Speaker. Furthermore, it has been our experience that evaluators always ask, can covert operations produce evidence that stands up in court? This clause, Mr. Speaker, firmly answers yes. It strengthens our investigative tools, ensuring that criminal cases are not lost because evidence is inadmissible. Mr. Speaker, Clause 9 makes amendments to the FIU-TT Act, Chapter 7201, to improve the effectiveness of the Financial Intelligence Unit as both a financial intelligence unit and supervisory authority tasked with strengthening the AML-CFT-CPT supervision. For members of the listening audience, Mr. Speaker, the AML-CFT-CPT legislation deals with the anti-money laundering, countering the financing of terrorism, and the Counter-Proliferation financing legislation, Mr. Speaker. Mr. Speaker, the amendments to this Act seek to strengthen the FIU-TT's enforcement powers through oral directives, penalties, and publication of fines. It extends the registration and renewal requirements for listed businesses and non-regulated financial institutions. It empowers the FIU-TT to refuse or revoke registration for unfit or high-risk persons or entities. It expands the supervisory cooperation and information sharing with regulators and law enforcement. It introduces risk-based monitoring requirements and power to demand financial statements, extend the AML, CFT, CPF compliance obligations to non-profit organizations, and replace certain criminal penalties with administrative fines to streamline enforcement. Mr. Speaker, the amendments to the FIU-TT Act aim to bring Trinidad and Tobago's legislation in direct harmonization with the FATF definitions, standards, and technical compliance requirements, mainly FATF Recommendation 26 on regulation and supervision of financial institutions and Regulation 29 with regards to financial intelligence units. In essence then, Mr. Speaker, the FIU-TT will operate more like a regulator in addition to acting in the capacity of an intelligence unit. Entities under its supervision will face higher compliance costs and obligations, but the system will be far more robust against money laundering, terrorist financing, and proliferation financing risks. Mr. Speaker, FATF Immediate Outcome 6 focuses on the effectiveness of the FIU. This clause ensures our FIU is not just a paper tiger, but it will be a strong, agile, and effective watchdog. Evaluators will look closely at FIU powers, and this legislation strengthens our hands considerably. Mr. Speaker, Clause 10 seeks to amend the Income Tax Act, Chapter 7501, to empower the Board of Inland Revenue with investigative powers necessary to detect and deter tax evasion. This is an important development in our legal framework, Mr. Speaker, because for the first time, and may I repeat, for the first time, the BIR will have explicit statutory authority to investigate tax-related offenses rather than being confined to its traditional role of assessing returns and collecting revenue. For the first time, the BIR will have explicit statutory authority to investigate tax-related offenses, Mr. Speaker. This amendment authorizes the BIR to investigate offenses under the Income Tax Act and other offenses that come to its attention, exercise all powers given under the Income Tax Act or other laws, take and record statements from taxpayers, employees, agents, or any other relevant person, require production of books, records, and documents, and cooperate with law enforcement and competent authority, subject to the safeguards in Section 4 of the Act. With specific regard to tax crimes, Mr. Speaker, that are predicate offenses for money laundering under FATF Recommendation 3, the money laundering offense will be addressed, as this amendment ensures that Trinidad and Tobago can fully investigate and prosecute tax-related money laundering. Furthermore, these amendments enhances evidence-gathering capability in tax evasion and related financial cases, crime cases, strengthens investigative reach, and closes loopholes that allow offenders to withhold information. The amendments, Mr. Speaker, will also improve interagency coordination in tackling tax evasion, money laundering, and terrorist financing. In essence, then, Mr. Speaker, tax evaders and those using tax structures to launder money and finance terrorism will now face greater risk of detection and prosecution, as the BIR will operate more like a law enforcement body in financial crime matters. Mr. Speaker, FATF Recommendation 3, 9, and 31 make clear that countries must treat tax evasion as a serious financial crime and must empower competent authorities, including the tax authority, with adequate investigative powers. In previous evaluations, Mr. Speaker, Trinidad and Tobago was found lacking in this area, and Clause 10 directly addresses that deficiency. It ensures that when FATF examiners arrive on our shores for the 5th round on-site mutual evaluation, we can demonstrate for the first time that our tax authority is not a passive administrator, but an active enforcer within the AML-CTF framework. But, Mr. Speaker, the importance of this amendment goes beyond satisfying FATF's technical requirements. Tax evasion robs the state of much-needed revenue, undermines public confidence in the fairness of the tax system, and provides fertile ground for broader tax schemes. Those who launder the proceeds of crime often disguise their activity through fraudulent filings, offshore arrangements, and shell companies that conceal taxable income. By empowering the BIR with investigative authority, we are equipping the state to protect the Treasury, reduce opportunities for abuse, and reinforce the integrity of our financial system. This amendment is essential not only to pass our mutual evaluation, but also to safeguard our country and ensure that every citizen and business contribute fairly to national development. Mr. Speaker, we are aggressively seeking to protect the public purse, an objective that every member of this Parliament should endorse today. I call on citizens to pay close attention to this debate, to see clearly where each of their elected representatives stands in the fight against crime and criminality. Mr. Speaker, Clause 11 amends the Companies Act by enhancing beneficial ownership transparency and corporate accountability. The reforms to the Companies Act focus on prohibiting nominee directors in order to prevent the misuse of nominee arrangements to conceal beneficial ownership, extending offences and compliance duties to external companies, expanding beneficial ownership disclosure, and requiring timely access by competent authorities. For far too long, Mr. Speaker, nominee directors and opaque ownership structures have allowed companies to be misused as fronts for money laundering, tax evasion, and corruption. This clause prohibits the appointment of nominee directors and strengthens the annual return obligations for external companies. These arrangements, Mr. Speaker, align with FATF Recommendation 24 on beneficial ownership transparency and Recommendation 25 on legal persons. When effective, amendments intend to improve transparency of corporate control and prevents the use of nominees from hiding behind beneficial owners consistent with the FATF recommendation requirements. Mr. Speaker, this is one of the most crucial areas of our upcoming 5th round mutual evaluation. Evaluators obviously will question whether Trinidad and Tobago can identify the true natural persons behind legal entities, and this clause 11 will allow us to answer with confidence. It ensures that competent authority have timely access to accurate information. It closes dangerous loopholes, and it strengthens our ability to prevent companies from being used as anonymous shells for illicit activity. Mr. Speaker, Clause 12 amends the Partnership Act, Chapter 8102, and introduces similar beneficial ownership requirements for partnerships. The amendments strengthen beneficial ownership transparency, revise the penalty regime, and introduce a penalty waiver mechanism for partnerships. Clause 12, Mr. Speaker, seeks to insert more detailed beneficial ownership information as required in registers and mandate that partnerships must provide beneficial ownership information to competent authorities within 30 days of request. Furthermore, the penalties for late filing is reduced and capped with the Minister empowered to amend and providing a ministerial waiver to allow amnesties for late filings. Mr. Speaker, by the imposition of a statutory duty to disclose beneficial ownership information promptly upon request, we are giving law enforcement agencies timely access and ensuring cognizant, consistent alignment with the Proceeds of Crime Act definition of competent authorities. It strengthens transparency of partnerships and ensures investigative authorities can access beneficial ownership data quickly, closing the FATF identified gap in Trinidad and Tobago under Recommendation 24. Furthermore, making penalties more proportionate and predictable ensures that partnerships face deterrence but not excessively financial burdens, and provides flexibility by allowing the minister to adjust penalties without amending the Act. The effect of these amendments encourages compliance while maintaining fairness, supporting FATF's proportionate requirement of the recommendations, Mr. Speaker. In practice, Mr. Speaker, partnerships can no longer hide beneficial owners or indefinitely delay filings. By extending beneficial ownership obligations to partnerships, this government is demonstrating that we are serious about closing every possible loophole and ensuring that no legal entity can be exploited to hide the proceeds of crime. The registry will be more accurate, enforcement agencies will have faster access to data, and Trinidad and Tobago will be closer to compliance with FATF Recommendation 24. Mr. Speaker, Clause 13 seeks to amend the Registration of Business Names Act, Chapter 82-85. The amendments therein ensures that all businesses operating in Trinidad and Tobago are registered promptly, introduced stricter timelines, clearer penalties, and a new waiver mechanism for firms and individuals required to register business names. These amendments seek to further promote compliance and transparency in line with the FATF Recommendation 24 on beneficial ownership and legal persons. Mr. Speaker, while some may think this is an administrative matter, it is in fact a crucial reform for our anti-money laundering and counter-terrorism financing regime. FATF standards make it clear that criminals often use small informal business structures as fronts to launder illicit funds. By bringing sole traders and small enterprises firmly within the compliance net, Clause 13 ensures that competent authorities will have visibility into who is actually behind these businesses, and evaluators will see that Trinidad and Tobago has a risk-based framework that does not leave out any sector. Mr. Speaker, Clause 14 amends the Securities Act 8302 and strengthens oversight of registrants under the Securities Act. These amendments significantly enhance transparency, accountability, and integrity within the Trinidad and Tobago's securities sector. The scope of beneficial ownership is broadened to capture indirect and ultimate control. Robust financial reporting obligations for registrants are introduced. Proportionate sanctions for non-compliance is enforced, and fit and proper tests are enhanced to exclude entities and individuals linked to terrorism financing, sanctions breaches, or securities fraud. Mr. Speaker, these amendments additionally set timelines, auditing standards, qualifications for auditors, and empowers Trinidad and Tobago Securities and Exchange Commission to act on deficient reports. The insert of a Part 4 significantly strengthens financial transparency and accountability of all registrants. It establishes clear statutory deadlines, imposes auditing standards and obligations for auditors to alert the TTSEC, gives TTSEC explicit enforcement powers in cases of deficiencies, and provides regulators with continuous and comparable financial data for effective supervision. This closes a gap identified by the FATF group in monitoring these designated non-financial businesses and professions, and securities actors. It ensures that the TTSEC can identify risks earlier, intervene where registrants show financial weaknesses, and hold both registrants and auditors accountable. Mr. Speaker, in addition to financing compliance monitoring, necessary for FATF Recommendation 26 to ensure securities intermediaries are adequately supervised, and collectively, these amendments advance compliance with FATF Recommendation 10 on beneficial ownership of legal persons, 25 on transparency and beneficial ownership of legal arrangements, 27 on powers of supervisors, and 35 on sanctions, bolstering the country's AML-CFT framework and aligning our securities regulation with global standards. Mr. Speaker, Clause 15 amends the Non-Profit Organization Act No. 7 of 2019 and seeks to enhance transparency and compliance obligations for non-profit organizations. Mr. Speaker, the amendments to the NPO Act enhance the accountability and regulatory oversight of NPOs in Trinidad and Tobago by requiring disclosure of branch information and beneficial ownership data, adjusting penalties to ensure fairness while maintaining deterrence, extending compliance duties to members, and enabling ministerial discretion to waive penalties. The law aligns more closely to global AML-CFT standards. These reforms strengthen compliance within FATF Recommendations 8 on non-profit organization, 24 on transparency and beneficial ownership of legal persons, 25 on transparency and beneficial ownership of legal arrangements, and 35 on sanctions, mitigating risks of misuse of NPOs, non-profit organizations that is, for money laundering or terrorist financing. In the upcoming mutual evaluation on site, Mr. Speaker, evaluators will question whether Trinidad and Tobago has implemented proportionate measures to protect the sector while enabling it to function effectively. Clause 15, this clause, Mr. Speaker, ensures exactly that balance. It provides regulators with the information they need to identify risks and act where there are concerns, while also giving legitimate charities and NGOs the space to continue their vital work. This is not only about compliance, but protecting the integrity of our non-profit sector, which so many of our citizens depend on. Mr. Speaker, I now turn to the Counter-Proliferation Financing Bill 2025, which I will also go through clause by clause. This bill forms a crucial pillar of Trinidad and Tobago's national anti-money laundering, counter-financing of terrorism, counter-proliferation financing strategy. Mr. Speaker, the issue at hand is one that lies at the very heart of our national security, our international obligations, and the protection of our financial system. That is, the urgent need for comprehensive risk-based legislation to counter proliferation financing. For the benefit of the listening audience, Mr. Speaker, proliferation financing is the act of providing funds or financial services that support a wide range of activities, including the development, manufacture, acquisition, or spread of weapons of mass destruction and the systems that deliver them. This includes nuclear, chemical, and biological weapons, instruments so destructive that they threaten international peace, security, and humanity itself. Mr. Speaker, we cannot underestimate this risk. Around the world, states and non-state actors have sought to acquire nuclear technology, chemical agents, and biological materials. To do so, they rely on financing, the oxygen without which proliferation cannot survive. While direct involvement in proliferation financing is deliberately and typically deliberate, regulated entities can inadvertently become enablers due to gaps in controls, insufficient awareness, or inadequate compliance mechanisms. Indeed, we have seen around the world how front companies and trade transactions have been used to acquire dual-use goods. Those are items with both civilian and military applications, and which are later diverted to weapons programs. We have also seen funds moved across borders through seemingly ordinary transfers, only to be used to fuel activities that undermine international peace. In every case, Mr. Speaker, financial systems were instrumental in enabling these transactions. Without robust legislation, Mr. Speaker, our financial sector will remain vulnerable and capable of being exploited by those who recognize that vulnerability. It is therefore critical that we act with haste to ensure that we are not utilized as a conduit, which will cause us to be exposed to reputational harm, financial exclusion, and even international sanctions. Mr. Speaker, the FATF has made our obligations clear. FATF Recommendation 1 explicitly states, and I quote, "Countries should identify, assess, and understand the money laundering, terrorist financing, and proliferation financing risks for the country, and should take action, including designating an authority or mechanism to coordinate actions to assess risks and apply resources aimed at ensuring the risks are mitigated effectively." Notably, Mr. Speaker, this requires us to adopt a risk-based approach. This means that governments, supervisors, financial institutions, and listed businesses must understand where they are vulnerable and must apply enhanced measures where risks are higher. Legislation, Mr. Speaker, is the backbone of this risk-based approach. Without it, financial institutions, listed businesses lack clear authority and regulators lack teeth. Proposed regulations must therefore mandate risk assessments of proliferation financing threats and empower the regulators and financial institutions to apply enhanced due diligence in high-risk areas. FATF Recommendation 7 provides, and I quote, Mr. Speaker, "Countries should implement targeted financial sanctions to comply with UN Security Council's resolutions related to the prevention, suppression, and disruption of proliferation of weapons of mass destruction and its financing. These resolutions require countries to freeze without delay the funds or assets and to ensure that no funds or other assets are made available directly or indirectly to or for the benefit of any person or entity designated by or under the authority of the United Nations Security Council," end quote. In other words, Mr. Speaker, the creation of law which prohibits any citizen, business, or financial institution from dealing with frozen assets in any way is imperative. There must be a prohibition on allowing anyone in our jurisdiction from making funds available or assets available to such designated parties. FATF Recommendations 1 and 7, Mr. Speaker, provides us with a clear framework. Identify and mitigate risks through a risk-based approach and implement targeted financial sanctions without delay. It is a fact that our current legal framework does not provide adequate provisions for supervision and enforcement. Notably, there are no legislative mechanisms to implement targeted financial sanctions under Recommendation 7 with the necessary speed and precision that is required. These gaps leave us exposed. They leave us vulnerable, and they leave us out of step with the international community. There is therefore an urgent need for a comprehensive legal framework that implements the FATF recommendations as it relates to counter-proliferation financing, thereby mitigating any associated risks and ensuring that this country can be found compliant under the FATF technical and effectiveness assessment. Mr. Speaker, before I move to examine the bill on a clause-by-clause basis, I also wish to advise members that there's a list of amendments that I propose to circulate with members, but relate to clause 2, 3, 4, 5, 8, 12, and 13 of the bill. I now intend to examine the bill clause by clause. Mr. Speaker, clause 2 of the bill, clause 1 of the bill contains the short title of the bill, which is cited as the Counter-Proliferation Financing Act 2025. Clause 2 of the bill contains the interpretation clause, which identifies the reporting entity under the Act as being the financial institutions, having the meaning assigned to it under Section 2 of the Proceeds of Crime Act, Chapter 1127, and listed businesses, a business or profession listed under the first schedule of the Proceeds of Crime Act. It also defines the listed entities in respect of whom financial institutions and listed businesses are required to report, as being those individuals or entities in respect of whom a freezing order relative to proliferation financing has been made under the Economic Sanctions Act. The bill also identifies Central Bank of Trinidad and Tobago as the supervisory authority in respect of financial institutions licensed under the Financial Institutions Act, Chapter 8401, and the Insurance Act, Chapter 7950, whereas the Trinidad and Tobago Securities and Exchange Commission will be charged with the supervisory authority function in respect of persons registered under Section 51(1) of the Securities Act 8302. In addition, Mr. Speaker, the FIUTT will be the supervisory authority in respect of listed businesses and financial institutions as non-regulated financial institutions under the Financial Intelligence Units of Trinidad and Tobago Act, Chapter 7201. These supervisory authorities will be charged with the supervision of these entities under its remit, as well as compliance with the Act generally. Clause 3 of the bill places an obligation on financial institutions and listed businesses, upon having been notified of the list of listed entities, to immediately inform the FIUTT whether a listed entity has property in the financial institution or business, whether any transaction is being conducted involving property owned or controlled by a listed entity, or whether the financial institution or listed business has funds or other assets of persons acting on behalf of the listed entity. By this clause, the financial institutions and listed businesses will also be obligated to submit a suspicious activity report in instances where a listed entity or person acting on its behalf attempts to enter or continue a business relationship with those institutions or businesses and shall be barred from entering or continuing same. Mr. Speaker, this clause Mr. Speaker, this clause operationalizes the requirement under FATF Recommendation 7, which demands that targeted financial institutions be implemented, targeted financial sanctions be implemented without delay. In FATF language, that means that actions must be taken within hours of notification, not weeks. Mr. Speaker, this provision ensures that we meet that test, and that no sanctioned individual or entity can move funds through our financial system once they are listed. Mr. Speaker, Clause 4 of the bill requires that financial institutions and listed businesses keep and maintain records pursuant to regulations under the Act. This clause also imposes an obligation on financial institutions and listed businesses to file suspicious activity reports with the FIUTT where there are reasonable grounds to suspect and believe that property within the institutions or businesses belong to or are derived from or generated from property owned or controlled by a listed entity or person acting on its behalf. The clause then goes further to impose additional obligations on financial institutions and listed businesses to the extent that they must pay special attention and report complex, unusual, or large transactions with no apparent economic or visible legal purpose. Those financial institutions or listed businesses will also be required to develop and maintain written compliance programs and otherwise monitor compliance with the regulations made under Section 13. The clause also creates a duty of confidentiality with respect to any suspicious activity or suspicious transaction report, the breach of which will constitute an offense. This duty, Mr. Speaker, will apply to both the director and staff of the FIUTT as well as persons within the financial institutions and listed businesses. Any person found in the breach thereof will be liable to summary conviction, to a fine of $5 million and to imprisonment for 5 years. Mr. Speaker, we are not making joke in the fight against crime. This clause goes to the heart of FATF Recommendation 11 and Recommendation 20. It recognizes that strong paper trails and confidentiality are essential to effective investigations, Mr. Speaker. FATF assessors will look closely at how records are kept, whether suspicious activity is properly reported, and whether staff are trained to avoid tipping off offenders, Mr. Speaker. Mr. Speaker, Clause 5 of the bill requires a financial institution or listed business that has reasonable grounds to suspect that property which it holds has been frozen pursuant to any written law implementing the FATF recommendations, to make a suspicious activity or suspicious transaction report immediately to the FIUTT. This clause also confers the staff of those institutions and businesses with protection from criminal, civil, or administrative liability where reports are made in good faith. Mr. Speaker, this provision is essential because it encourages institutions to act quickly and decisively without fear of reprisal. It ensures that the FIUTT gets timely intelligence, and it aligns us with international best practice. As FATF has said, delays in reporting can mean the difference between freezing illicit funds and losing them to another jurisdiction. Mr. Speaker, Clause 6 of the bill mandates the supervisory authorities to monitor the financial institutions and listed businesses under its supervision and to take necessary measures on a risk-sensitive basis to ensure compliance with the Act or any other written law which implements FATF recommendations as it relates to counter-proliferation financing. This is in keeping with FATF recommendations 26 and 27, which call for robust supervision of financial institutions and powers for supervisors to enforce compliance. With this law, Mr. Speaker, the law will not be toothless. With this law, Mr. Speaker, we ensure that supervisory authorities can take proactive, risk-based action. Mr. Speaker, Clause 7 of the bill authorizes the supervisory authorities to disseminate the findings of any national, sectoral, or thematic assessments of proliferation financing risks to the relevant financial institutions and listed businesses under supervision. This means that banks, insurance companies, and other listed businesses will be able to understand the risks identified at the national level and tailor their compliance accordingly. This provision operationalizes the FATF's call for a risk-based approach under Recommendation 1. It ensures that risk assessments do not sit on shelves collecting dust as present, but are actively used by industry players to strengthen controls. Mr. Speaker, Clause 8 of the bill permits the supervisory authorities to enter the premises of financial institutions and listed businesses under their supervision during work hours in order to examine business transaction records and client information records and ask any question relating thereto, determine whether there has been implementation of policies and programs required to ensure compliance with the Act or with any other law by which the FATF recommendations have been implemented, determine whether there is compliance with the Act and regulations or any other written law by which FATF recommendations as it relates to counter-proliferation refinancing has been implemented. In instances, Mr. Speaker, where the supervisory authority is the FIUTT is required by law to obtain the consent of the owner or the occupier of the premises for entry. Where the entity supervised by the FIUTT refuses to give consent, a police officer above the rank of sergeant may apply for a warrant to enter the premises accompanied by the officer of the FIUTT. The bill does not require the Central Bank of Trinidad and Tobago or the Trinidad and Tobago Stock Exchange Securities Exchange Commission, The bill does not require the CBTT or the TTSEC to obtain consent for the purposes of entry, as this consent already exists under its primary legal framework. Mr. Speaker, Clause 9 of the bill mandates financial institutions and listed businesses to develop and implement policies and programs on a risk-sensitive basis for the purpose of managing and mitigating proliferation financing risks and ensure compliance with the Act and any other written law by which FATF recommendations have been made. These policies and programs must be approved by the senior management of the relevant institution or business. Mr. Speaker, the FATF stresses in recommendation 18 that senior management involvement is critical. If compliance is not embedded in the culture of the institutions, then controls are ineffective. This clause ensures accountability at the highest level of management. Clause 10, Mr. Speaker, imposes a duty of confidentiality on the supervisory authorities not to disclose any information or documents which it has obtained in the course of its duties as supervisory authorities. Clause 11 of the bill seeks to create an offence for the breach of confidentiality in Clause 10, with a penalty on summary conviction of a fine of $250,000 and to imprisonment for 3 years. Mr. Speaker, this provision ensures the integrity of the system. It deters misconduct and reassures our international partners that sensitive data will not be compromised. Clause 12, Mr. Speaker, is about offences and penalties. This clause seeks to impose penalties for breaches of the obligations contained in Clause 5 and 6 of the bill and in respect of a breach of the regulations made thereunder. These penalties are set at, on summary convictions, fines of up to $2 million and 2 years imprisonment, and on indictment, fines up to $5 million and 7 years imprisonment. Mr. Speaker, this clause also introduces administrative monetary fines of up to $1.75 million, giving supervisory authorities the power to enforce compliance directly without lengthy court proceedings. That, Mr. Speaker, is exactly what FATF requires under Recommendation 35. Sanctions that are proportionate, dissuasive, and effective. Mr. Speaker, this is the kind of enforcement power that international assessors will expect to see and will see in place before our 2026 on-site evaluation. Clause 13 of the bill empowers the Minister of Finance to make regulations subject to negative resolution for the purpose of giving effect to the Act and is a usual element of modern bills. Clause 14 seeks to make consequential amendments to the Economic Sanctions Act, Chapter 8105, to impose a duty on the Attorney General to maintain lists of listed entities and individuals that are made in accordance with that Act. Mr. Speaker, these two bills are indispensable legislative package that will immensely aid our nation's ongoing efforts to protect our financial system and reputation on the international stage. The breadth of these reforms underscores one fundamental truth. Financial crime is not confined to banks or to traditional institutions. It extends to lawyers who may set up trusts, accountants who may form partnerships, non-profit organizations that may be misused to channel funds, securities dealers, money service providers, and even external companies seeking to take advantage of regulatory gaps. Taken together, these two bills directly target the core weaknesses identified by the FATF. Mr. Speaker, allow me to emphasize again the urgency of this moment. The fifth round mutual evaluation will not be satisfied with laws on the books. It will ask probing questions. Are these laws being enforced? Are suspicious transaction reports being filed and acted upon? Are beneficial ownership registries accurate and accessible to competent authorities? Are prosecutors and judges using these tools to obtain convictions? Have we addressed counter-proliferation financing adequately? Have we addressed service providers, Mr. Speaker? FATF's methodology makes this clear, one thing, very clear. Countries, Mr. Speaker, and I quote, countries must not only establish a necessary framework, but must demonstrate that the framework is producing results in practice, end quote. These bills, therefore, lay the legislative foundation for effective implementation and shows our prospective evaluators that Trinidad and Tobago is serious about closing compliance gaps. Mr. Speaker, this is not just about FATF. It is about our people. Corruption, money laundering, and terrorist financing robs citizens of opportunities. It distorts markets and it undermines the delivery of public services. When corrupt public officials embezzle funds or when criminal enterprises launder the proceeds of drug trafficking, it is ordinary citizens who suffer through reduced social services, higher costs of doing business, and diminished confidence in institutions. These bills, by criminalizing the deprivation of state revenue, by strengthening anti-corruption measures, and by enhancing financial transparency, strikes directly at those who would rob the public purse. Mr. Speaker, these bills are not simply a compliance exercise. It is a national security imperative, an economic safeguard, and a statement of our values. By passing them, we affirm that Trinidad and Tobago will not be a haven for dirty money, that we will not allow our financial system to be abused, and that we are committed to transparency, accountability, and good governance. We will send a clear message to our international partners that we are a credible, trustworthy jurisdiction. We send a message to our citizens that we are protecting their economy and their future. And we send a message to the FATF evaluators that Trinidad and Tobago takes its obligations seriously and is ready to demonstrate with effectiveness. Mr. Speaker, in closing, I wish to say this. The passage of each of one of these bills are not an end of the journey. It is a foundation upon which we must build effective implementation, rigorous supervision, and decisive enforcement. But it is a critical and crucial foundation. Without it, our evaluation will be doomed to failure. With it, we have the legislative tools necessary to show progress, to demonstrate compliance, and to secure our nation's future. I repeat, Mr. Speaker, that the nation is watching to see which of its elected representatives stand on the side of justice and support this legislation. Mr. Speaker, I therefore urge all members of this Honourable House to support this legislation. I beg to move.
Members